So it's late here on a Monday evening, and I've just had the opportunity to review the complaint that was released by the 50 state attorneys general, which details the problems in the mortgage foreclosure settlement agreement. Now, a little bit of background, all of you understand that attorneys general from all across the country had brought a variety of claims against the banks and institutions who've done such disastrous conduct and behavior all across this country. And over the course of at least the last year, the 50 state AG group met to review and consider what charges and what conduct would be investigated. Now, here in the state of Florida, we were ground zero. We remain ground zero. As most of you know, the investigation into the improper bank conduct began under Bill McCollum and then really heated up as the conduct that was investigated and the behavior that was continually documented continued to be documented, and we collected more and more information. Now, many of you know the heroes in the foreclosure fight here in Florida had been June Clarkson and Teresa Edwards working within the Attorney General's office, who were collecting information from attorneys and advocates all across the state of Florida. One of the pioneers in the battle to seek out justice and to do right by law has been an attorney named Lynn Sismoniak. She's been a true hero from the beginning to Floridians all across the state and to attorneys especially. Whenever an attorney needed help or assistance, Lynn was always available, giving of her time, her talent, and her treasure to help any attorney who needed assistance and consumers the like. Now, what's most significant is that after Bill McCollum left office and Pam Bondi came in, the two attorneys who were primarily responsible for investigating all this foreclosure misconduct, June and Teresa, were summarily let go from the office. And in this new administration, it became clear that mortgage fraud investigations weren't much of a priority. Two attorneys were effectively fired, and then subsequently an Inspector General report, Jeff Atwater, looked over the investigations and came to the very whitewashed conclusion that nothing was wrong with those firings. Now, why that's so significant is Lynn Sismoniak's name is mentioned throughout that entire Inspector General report, along with Teresa and June, in most unflattering ways. I found that absolutely despicable because these individuals, Lisa Epstein and Lynn in particular, were public citizens who were doing the right thing, reporting to their government out of a sense of community obligation, and frankly, Lynn out of a sense of ethical obligation as an attorney practicing law. And yet, if you read that Attorney General's report and the Inspector General's report, you will see that really Lisa and Lynn became the targets of this report as if they had done something wrong. And why I find that most significant is the headlines today report that as a consequence of reporting all of this behavior, doing the right thing, our friend Lynn will receive some significant remuneration. The way the False Claims Act is set up is that if you set about to help our government recover money that was paid out improperly, you were paid some portion of that as a benefit or a bonus for helping recover money that was improperly taken. With that as a background, I want to draw everyone's attention to some of the documents that have been posted on the Attorney General's settlement website. Begin with the complaint around page 21. You know, so much of this is fluff. There's frankly not much substance in the complaint for problems of this size. The first 20 pages or so deal only with precatory or introductory information and nothing really of consequence. It's only when you get to page 21 where we start to see real documentation of the extraordinary abuses, and I can say this now, unfair, deceptive, and unlawful practices that were engaged in by the banks and institutions. Again, the banks and institutions engaged in unfair, deceptive, and unlawful practices. Now, what's so significant about this is if you look through this complaint and you see where all of this is detailed, you'll see extraordinary conduct that's been investigated here. And in this complaint, findings of fact that in fact these banks did engage in grossly abusive practices, and frankly practices which are just against the law. You and I don't get away with making false statements in bankruptcy proceedings to federal bankruptcy trustees and judges at all, even a little bit. And yet, as this lawsuit here indicates, this was done on a repeated and repetitive basis, to the tune of hundreds of millions, potential billions of dollars. But getting then into page 27 and looking at page 64, or paragraph 64, where it details the abuses that the banks regularly engaged in the foreclosure process, beginning at paragraph 64, where it asserts with specificity that the banks failed to follow appropriate foreclosure procedures, and that they engaged in preparing, executing, notarizing, or presenting false and misleading documents. Again, read that. In this settlement agreement, there is a finding of fact that the banks prepared, executed, notarized, and presented false and misleading documents with courts. They prepared and executed false affidavits in these foreclosure proceedings. The thing that's so absolutely disturbing about this entire settlement agreement is that when you have a complaint, a law enforcement complaint, making such extreme findings of fact, and yet they're able to get away with it, which not even a slap on the wrist. We'll get to that in a second. But I just encourage you to begin reading at page 21 and read the detailed recitation of the wrongdoing and the federal codes that have been violated by the banks over and over and over again. And most significantly, when they're beginning at page 34, the bank's bankruptcy-related conduct. Read what it says that they did in the conduct of bankruptcy proceedings. Grossly improper conduct, lying to federal judges. And the consequence for that is just a slap on the wrist, if that. It's hardly even a good stern talking to, as we'll get to in a minute. But frankly, the bottom line with this is, even though there is a settlement provision and there is an alleged payment of money that will be part of this, what we all find so disturbing is that that money isn't necessarily coming out of the wrongdoers themselves. The banks aren't paying for this. Much of this is being shouldered on the backs of the investors. It's an unfair, I think unconstitutional taking, because what they're doing here as part of the settlement is going back and sticking their hands into the pockets of investors and selling this as some kind of settlement for consumers. But this is coming out of our pocket. But, when you go through and read the counts beginning at page 39, and you read the count 2, unfair and deceptive consumer practices with respect to foreclosure processing, and you see the detail about what exactly it was they were getting away with. Getting down into 3, the unfair and deceptive with loan origination, and in the biggie on page 41, violations of the False Claims Act. False claims is important because what this asserts is that the banks and the institutions were engaging in false, improper, I think criminal conduct that resulted in them receiving hundreds of millions of dollars of taxpayer money. That's my money. That's your money. They lied, they cheated, they stole, and as a result of doing that, the reward for that is hundreds of millions of dollars. That's the false claims element of it. Again, the bankruptcy violations, but violations of Service Member Civil Relief Act. They violated the rights of our soldiers. They engaged in bankruptcy misconduct in page 44 there, and common law claims relating to bankruptcy misconduct. The thing that is so disturbing about this on a magnificent basis is the fact that even though we have all those detailed findings of fact that are grossly improper and grossly out of sense of any legal bounds conduct, is the fact that the penalties associated with it are so grossly out of whack. Whatever it is, if it's $25 billion, it means absolutely nothing, especially when the banks and institutions themselves are not really paying that. Much of this burden is being shouldered by the investors. And so, to those of you who are invested in 401ks and other investment vehicles in mortgage-backed securities, you actually will be bearing most of the burden of this. And, as I look down here, the names of the attorneys general that are signed on the bottom line here, this truly is a settlement agreement with financial terrorists, with criminals, with wrongdoers, and our attorneys general from all across this country signed on to this, and it's an abomination. It's an embarrassment for our country. To those of us out there who feel as if there are two sets of rules out there, one for the banks and institutions, the Wall Street players, and the other for you and I. This is more proof of that. And frankly, it just concerns me even more to see this settlement agreement put into writing, even more than I did when I first heard about it, because this is simply going to give more fodder, frankly, well-grounded fodder for those of us all across this country who believe that this country has gone grossly unfair, that there's no sense of law or the rule of law that applies to anybody but you and I. So I encourage everyone to read this agreement very carefully. The language is very clear. It's very easy to understand. And when you do so, in fact, I encourage you to share with me your thoughts and share the thoughts with our attorneys general for what it's worth, although the fact of the matter is that no one seems to care anymore. Those at the top of the pyramid, from your president all the way down, certainly your governors and attorney generals explicitly in this agreement here, have shown that they don't care at all for the people of this country, and they're willing to turn over the keys to the State House and the keys to our laws to the banks and institutions. There need to be indictments. There is criminal conduct that is identified in this complaint, and that conduct is bringing down this country. Until there is some kind of recognition that the gross conduct that we're engaged in by the banks and institutions must be punished, then this won't be right. One final point. One of the most glaring things about this settlement, I think one of the most, but frankly they're all very bad, but one of the things that bothers me the most is there is acknowledgement in here that the banks and institutions were telling their customers not to be current on their loans so that they could qualify for the settlement programs, the modification programs that were being offered by the federal government. And this is important. How many consumers, was it hundreds of thousands, I don't know, tens of thousands of consumers across this country believed in the representations made by the banks and institutions when they told them, do not be current on your loan, you must be delinquent on your loan in order to qualify for these federal programs. They were doing this systematically all across the country, and as a result of that, consumers got into default, and then they were denied loan modifications. Now, for the tens of thousands of Americans over there who in good faith did what the banks told them to do, and that was explicitly don't make your mortgage payment, and then as a result of doing that, they got thrown into foreclosure, and now that they're in foreclosure, they're going to lose their homes. Where is the settlement for them, for those people that lived in homes for decades and are now losing everything because they did what the banks told them to do, as explicitly identified in this agreement? Where is the settlement for them, I ask? This is an unjust country that we live in, and this is further proof of it right here in writing. I encourage you to look at it carefully, make your own comments, and share this with others.